Hello and welcome everyone to webinar 2 of today's day 1 of the ICC United Kingdom's annual Arbitration ADR conference. For those that couldn't join at 10 a.m. this morning, we had a great session from the YAF network. Our 2 new YAF leaders, Nora and Trisha, laid on a meeting all about your first appointment. So if you didn't manage to watch it, or you'd like some of your team to perhaps watch it afterwards, don't worry, it's going to be made available on our YouTube channel after the event, and we'll be sending out a notification after the 2-day conference with all the links from in the next 2 days. Just wanted to take the opportunity to say thank you to all of our sponsors who you can probably see on the bottom of your screens now. EY, 39 Essex Chambers, Jasmundi, Charleview, Latham & Watkins, and then our host for tomorrow, if you're joining us in person, at Simmons & Simmons. So today's session, the next one we have is on insolvency meets international arbitration, and I'm delighted to hand over to Patrick Taylor, who's partner at Debevoise and Plimpton. Patrick, if you'd like to come up onto the screen and introduce your panel for today, please.
Thank you very much, Natalie. Well, it's my pleasure to be here today, and my pleasure to be joined by such a wonderful panel. We have James Barratt, who is a partner and co-head of international disputes for Europe at Vinson and Elkins, recognised as a leading arbitration and litigation lawyer. He's got a significant practice in contentious restructuring matters at the intersection of international arbitration and litigation, and typically these matters involve parallel proceedings in England and other European jurisdictions. So it'd be great to hear his perspectives. Angeline Welsh, KC, barrister at Essex Court Chambers. Angeline is also a recognised leader in the field of international arbitration, appearing regularly as an advocate before commercial and investment treaty tribunals, the English, the BVI, and the Belize Court. Last year, Angeline was recognised as one of GAR's 45 leading practitioners under the age of 45, and shortlisted for International Arbitration Silk of the Year by Legal 500. Third, Emily Saunderson, barrister at Quadrant Chambers. Emily is a commercial litigator with particular specialism in commercial fraud, banking and finance, and insolvency. In 2024, Emily was shortlisted for Financial Services and Insurance Junior of the Year by Legal 500. And interestingly, before her career in law, Emily was a financial journalist covering the global derivatives market. And last but certainly not least, Kushal Gandhi. Kushal is a partner in the finance disputes team at CMS in London, specialising in finance and fintech disputes. He's an active member of the CMS India desk and an experienced litigation and international arbitration practitioner. He is also the co-editor of Elga's Arbitration and Insolvency text. So 4 very illustrious practitioners with some very interesting perspectives on the subjects that we're going to be discussing today. So we're going to turn first to some scene setting to explore why there is tension between arbitration and insolvency processes. And for that, I'm going to turn first to James.
Well, Patrick, thank you very much indeed for that generous welcome to all of us. Arbitration and insolvency, as indeed I think the blurb for this conference explained, are often described as 2 worlds with different perspectives on fundamental aspects of the legal system. Whereas arbitration affords primacy to party intent, insolvency is inherently concerned with the rights of third parties, and it is indeed often described as a collective remedy. Complex legal and policy questions arise when these 2 disciplines are forced to interact, as they most clearly were forced to interact in June this year in the well-known decision of Cian Participation Corp and Halimeda International, a decision of the Privy Council. We'll be discussing later that decision in detail, but just in a sentence or 2, so as to frame the policy issues, I just want to summarise what that decision determined. It decided that there would be no automatic stays or dismissal of a winding up petition, as we all know, being typically the starting process in terms of an insolvency process against companies in England and other jurisdictions to seek to appoint a liquidator. There'll be no automatic stays or dismissals of a winding up petition where the debt arises out of a contract subject to an arbitration agreement, and that is so even where there is a valid and binding arbitration agreement. A winding up petition would only be stayed where the underlying debt is disputed on genuine and substantial grounds, and that's the test that Halimeda has now set, in circumstances where the arbitration agreement is generally worded. Now, notably, Halimeda overturns the position that was English law for the last decade, set out in the Court of Appeal decision of Salford Estates No. 2, where the courts would typically dismiss or stay winding up petitions in virtually every case, regardless of whether the debt could be disputed on genuine and substantial grounds. Now, all of us as arbitration practitioners, I think, need to consider what are the policy issues involved in drawing the line between this intersection of arbitration and insolvency. This is relevant not just in terms of stays of proceedings, but also arbitrability, applicable law to questions where insolvency arises, and of course the cross-border impact of circumstances where there's an insolvency of a party in a jurisdiction different from that where the arbitration is seated. What must the tribunal do, etc.? Who determines these questions? Now, in broad terms, from a policy perspective, insolvency is typically seen as being an integral part of any nation's legal and economic infrastructure. It's a fundamental part as to how companies are organized and how debts are determined. Now, the values underpinning insolvency, certainly throughout the common law world, focus on the fair distribution of an insolvent estate's assets between creditors of the same class, pari passu, seeking to maximize the return to creditors and protecting the public interest. We see that, for example, with the insolvency waterfall in terms of which debts have priority. Now, arbitration, as we all know, is of course a private means of resolving disputes that arise between entities. Party autonomy and the consensual nature of arbitration are all fundamental leitmotifs of that system. Pacta sunt servanda, as we all say, in terms of agreements are there to be enforced, most clearly seen in relation to mandatory stay provisions. Now, arbitration agreements have both positive and negative aspects to them. The most obvious one, of course, is the positive aspect, the obligation to arbitrate matters that fall within the scope of the arbitration agreement. Now, the negative aspect is the obligation on the party not to commence proceedings in respect of matters covered by the agreement in courts or other fora. The debate and focus in Halimeda was really on the meaning of matters that are subject to the arbitration agreement. Now, the Privy Council held that the negative arbitration agreement, the negative obligation in the arbitration agreement was not frustrated, as it was a negative obligation not to have disputes resolved by any other court process, and that winding up petitions do not do that, because they say they determine nothing about a petitioner's claim, nor about the quantum of that debt. The court also found that the policies underlying the arbitration legislation are also not frustrated, because insolvency legislation requires that the debt be genuinely disputed on substantial grounds. The creditor must first establish that claim, if it is disputed on those grounds, by arbitration. So that's where the court drew the line. But does it strike the right balance? If one thinks about this, Halimeda essentially allows, if we're dealing here with in English, or indeed a BVI, or if it is the law Hong Kong or Singapore company, essentially allows an ICC judge to determine whether there is a dispute which would be subject to the arbitration agreement. Now, this is not the same ICC that we know and love and who kindly arranged this conference. It's not the International Chamber of Commerce. It's an Insolvency and Companies Court judge sitting in the High Court in London. This ICC judge will be making a determination as to whether or not there is a genuine and substantial dispute. Now, when international parties bargain for London arbitration, they do not necessarily expect, I would suggest, to end up before an English court to essentially determine whether or not this is a claim that can proceed. It also raises questions, I think, from a competence perspective. Who really is the entity, who really is the body that should be deciding this question? The English court, as Halimeda says, or the tribunal? Halimeda also allows a party, I think, to apply pressure on an alleged debtor to pay up immediately, lest face the decision by the English court, rather than seeking to go through the contractually mandated arbitration provision. But yet, against these pro-arbitration perspectives, which all of us as arbitration lawyers see, there is, of course, the insolvency perspective, which says, Well, simply because you agree and make a bargain to arbitrate, that does not mean that parties are absolved of all other rights and statutory obligations. Parties remain subject to the applicable regulations, including collective remedies such as insolvency. To say otherwise, one may say, would be to accede to a theory of arbitration that's essentially delocalized, much along the lines of the late Emmanuel Gaillard suggested in his well-known book. But of course, that's not the balance that the English courts and English law have decided. It may also be said, in terms of the benefits of this approach, that of course one of the criticisms of arbitration is that there's no summary judgment process. There's no process to weed out hopeless defences. A finance party may be more amenable to agreeing to an arbitration agreement if it knows it's able to put a company into insolvency if necessary. So to conclude, I can see the competing policy arguments, but in my view, Alameda focuses too much on the public policy issues in favour of insolvency processes and gives too little consideration to those from an arbitration point of view, and particularly from the focus of who decides the question as to whether there is or is not a substantial dispute. But it will certainly be interesting to watch how this decision is implemented in practice. And with that, I will hand back to you, Patrick. Thank you.
Thank you, James. So, I mean, there's obviously the interaction between when a winding up petition will be stayed in favour of arbitration and when arbitration will be stayed in favour of winding up proceedings. And you've touched on some of the recent thinking on how that will play out in England. But Kushal, perhaps you could comment further on those two sets of circumstances and the most recent decisions in these spaces.
Yeah, thanks, Patrick. I think maybe what I'll do is just try and just recap where we were before Sign and Alameda in terms of the approach that the English courts were taking under Salford Estates, just to sort of set the context, because I think what James has been saying is perhaps reflective of a lot of the thinking that we've all had to date as a result of decisions like Salford Estates. So, just looking at the Salford Estates approach as it was, which I think currently is still relevant, as we'll hear later on in some other jurisdictions, which is the ability to present a winding up petition for claims arising from an arbitration agreement was something that was looked at in 2015 decision of Salford Estates. And what the court did there is it sort of said that although the mandatory stay provisions in Section 9 of the Arbitration Act do not apply to winding up petition, that's not the end of the matter. Because what Section 122 of the Insolvency Act does is confers on the court a discretionary power to wind up a company. And so what the court then went on to say is that unless there are wholly exceptional circumstances, it would not be appropriate for an English judge to inquire whether the debt is disputed in good faith on substantial grounds. The discretion in Section 122 to wind up the company must be exercised so as to uphold the policy of the Arbitration Act, discourage parties to an arbitration agreement from bypassing it as a tactic by presenting a winding up petition, and prevent one party from applying pressure on an alleged debtor to pay up immediately or face the burden of satisfying the court that the debt was bona fide disputed on substantial grounds. And finally, the policy also was to require the parties to adhere to their agreement as to the proper forum for resolution of such an issue. What James was sort of saying, which is, if commercial parties have bargained for arbitration, then that's what they should get. The court in Salford Estates also went on to sort of say that where a debt is mentioned in a winding up petition falls within the terms of the arbitration agreement and the debt is not admitted, that in itself was sufficient to constitute a dispute for the purposes of avoiding the winding up petition. And this was irrespective of whether there was any substantive merits of any defense. And that's the difference between having an arbitration agreement and a winding up petition being presented under Salford Estates and not having an arbitration agreement and a winding up petition being presented. It's that difference about, who is going to determine whether or not there is even a good faith dispute. And it was in those circumstances that the court basically said that, you know, they could exercise their discretion to either dismiss the petition or to stay it. That was the case in 2015. We've had multiple decisions since then that have sort of followed that approach, really. What the Privy Council now seems to be saying in Simon Halimeda is something different. And just to put it in context, you know, this was a claim involving, I think, something like $226 million under a loan agreement that contained a fairly widely drawn arbitration clause. It was disputed on various grounds, including a cross-claim and an allegation of a corporate raid. And the court, this was in the BVI, and the court did sort of find that the debt was not genuinely disputed on substantial grounds. This was then appealed, arguing that, you know, the court should just have followed Salford Estates and stayed or dismissed the liquidation application. The Privy Council basically rejected the argument, and they affirmed the appointment of the liquidators over the appellant. And in doing so, what the Privy Council did was basically conduct a fairly detailed analysis of the nature and effects of the liquidation process, the interpretation and scope of arbitration agreements, and the relevant public policies in both the BVI and in England and Wales. And having done so, it sort of concluded that the decision in Salford Estates was based on an impermissible and unexplained leap in the reasoning of the Court of Appeal as to the extent of the legislative policy behind the Arbitration Act, and that accordingly it was wrongly decided. The board basically said that a creditor's winding up petition or a similar liquidation application that does not trigger the mandatory stay provisions in what is Section 18 of the BVI Act. But they sort of concluded that the petition does not seek to and does not resolve or determine anything about the petitioner's claim to be owed money by the company, nor is the existence or amount of the debt a matter or issue for resolution in those proceedings. Now, again, as I think we may come on to discuss, I think that is quite a key tenet of that decision and approach, which is that, look, the Privy Council is saying, if a winding up petition is presented, this is not about the underlying contract. It's not about the debt, really. We're not making any findings about that. So the fact that there's an arbitration agreement is neither here nor there, I think, is effectively one of the things they seem to be suggesting. Because they're sort of saying that if a company is insolvent, then we have jurisdiction to be able to sort of determine that. They also held, though, that the contractual obligation embodied in typical arbitration agreements is to refer disputes to arbitration for resolution. And the negative obligation is that they are not resolved by any court process. And therefore, the presentation of a winding up petition does not offend the negative obligation at all, as it is simply not something which the creditor has agreed not to do. So again, they're taking that sort of policy argument and sort of, I think, attacking it slightly differently, which is they're sort of saying, look, if a company is insolvent, that's a different matter to whether or not there's a dispute under the arbitration agreement. And yeah, you can be held to your arbitration agreement and all of those good things that come with that. But that's not what we're looking at really here, are we? I think that's where the Privy Council, at least seems to me, were coming from. And I think it results in quite a significant difference in the practical impact of Salford Estates and the Privy Council's approach in Cyan. You could argue that the approach in Cyan gives more certainty and clarity because it's just binary, which is, you know, it's all about the liquidation. There is no difference whether or not you have an arbitration agreement or you don't. It wouldn't be any different if you hadn't chosen arbitration. And it's literally all about the winding up petition. But I think the slight issue with that is how that cascades down into practical life. And, you know, and I think in Cyan also that it does seem to suggest that if a company is insolvent, it's not about the dispute, but that to me feels sometimes is a bit artificial because it's always the reason why the winding up petition is there is because there is a debt under the agreement. Or it is being alleged that there is a debt under the agreement. And so there is a matter to be determined under the agreement whether or not there is a debt or not. And so the fact that you then have to sort of argue about whether or not there is a substantive dispute under the agreement does bring into those sets of proceedings, in my view, questions about the agreement for which parties have chosen arbitration, and should be allowed to go to arbitration. I think creditors, though, will have to think about this quite carefully, because if you're a creditor, and you decide to go for a winding up petition whether tactically or not, or whatever it may be, you're then, and if it turns out that the company is wound up and a liquidator is appointed, what then are you going to do as a creditor? You're then going to have to wait potentially for the liquidator to adjudicate on your debt. And if at that point in time the liquidator doesn't agree with you for any reason, you're then back into court potentially to object to the liquidator's adjudication, when actually you might have thought, well, hang on a minute, I thought I had an arbitration clause. So I think creditors will have to think more carefully before they present winding up petitions in some respects around agreements with arbitration, because if there is any layer of doubt that a liquidator may come to a different conclusion about the debt, then query if the creditors want to take the risk on allowing a liquidator to make that decision, or whether they might think, actually, we might be better off going to arbitration, getting an arbitral award, and then enforcing it and removing any layer of doubt there. I'll sort of pause there and then sort of hand back to you, Patrick, to sort of take us forward.
Thank you. I'm interested in the views of others, whether you expect to see strategic changes in how creditors will approach these issues as the balance has changed following Sound and Alameda.
So if I can jump in, one of the things that the Privy Council said in the Sion decision was that there's nothing anti-arbitration about it. Because in agreements where one party is likely to be the creditor, that party is going to have the whip hand in terms of determining the dispute resolution mechanism. And if there is no genuine dispute about the debt, the party is going to want to get the winding up procedure started as soon as possible and not waste time and money on an arbitration. And that, from my perspective, makes an awful lot of sense. I do a lot of banking litigation, and banking contract loan agreements tend not to be the subject to arbitration clauses. They tend to be subject to exclusive jurisdiction in respect of the high court jurisdiction. And that's presumably because nobody wants the faff and, frankly, the time and expense of pursuing an arbitration for a straightforward debt. So I can see where the Privy Council is coming from that perspective. Equally, if you're a debtor and you want to increase your prospects of getting some sort of settlement on a defence that has got no merit, I can equally see why you'd want to try and force it into arbitration. So this is a very pro-creditor decision, in my opinion.
Mm-hmm. Agreed.
And perhaps just to pick up where Emily started, sorry, Patrick, I'm trying to cut across you.
No, I saw you.
In a way, to take your analysis a bit further, Emily, it's a win-win from the creditor's perspective, because if they get it, if they file a winding up petition on the basis that there's no substantial dispute, and it comes back that that petition is an application for a stay on the basis there is a substantial dispute, then they end up in arbitration. So if there is something really significant to argue about, they will get their arbitration proceedings.
Yeah. So I should have mentioned earlier on at the outset that we have a Q&A function. We have some very knowledgeable listeners today, including, I think I saw on the list, Dr. Manuel Peñades on the line. So if you've got any comments or questions, please do use the Q&A function to do that. James has also posted the case names that he referred to earlier on, so that you have those there. And I'll keep an eye on the Q&A function, and we can address questions either as we go, or there'll be time at the end as well. So one tension that arises in the context of arbitration and insolvency arises because of what's arbitrable and what's not. And arbitrability places a limit on party autonomy. So, Angeline, perhaps you could explain to us what the current situation is on what insolvency issues are arbitrable.
Yes, thank you, Patrick. So there is some really interesting case law which actually dates in a way the Sion case relating to the stay. So what Kushal has just explained is in the Sion case, what the Privy Council started from the perspective is that the winding up proceedings which were brought by the creditor were not there to determine a claim, and therefore the equivalent of Section 9, where in the BVI and Science case didn't, or Section 9 in the English Arbitration Act, which provides for a mandatory stay of matters which ought to be referred to arbitration, didn't apply. But if one steps back, and this is where the arbitrability case law comes in, there was a case from the Cayman courts, also decided by the Privy Council, but in that case sitting as the final court of appeal for Cayman, the Family Mart decision, where the court did order a stay of winding up proceedings. So that on the face of it, there is a inconsistency there. But what the Privy Council did in the subsequent case of Sion and the BVI is they explained away the consistency. And I'll just explain how that was done before getting on to the arbitrability case law. So in order to explain that, it's probably helpful to just tell you what the Family Mart case was about. So that was essentially, or was ultimately the Privy Council decided, was a shareholders dispute. So there was a shareholders agreement which includes an arbitration clause, and a petition was filed by the 40% shareholder in Cayman for a just and equitable winding up on the basis that the shareholder had lost trust and confidence in the majority shareholder and in the management of the company's affairs, and the relationship between the shareholders had irretrievably broken down. Now, in the Sion case, what the court said was that you can distinguish the Family Mart case, even though it's a winding up petition, because it was a contributor's petition for a winding up on a just and equitable ground. And in that case, what the applicant had to show was circumstances, usually inequitable conduct by the other shareholders, which made it just and equitable to wind up the company. So even though the proceedings, so that raised issues which actually would have to be decided as properly resolved finally, as if it were a claim. And so in those circumstances, those were matters which were capable of falling within Section 9. So in a sense, what you have by both the Family Mart decision and the Sion decision is two types of winding up proceedings. If you like, the creditor petition, which the Sion purposes have decided that falls outside the scope of what would be Section 9 under the English Arbitration Act, or you have Family Mart where in that case it would fall within Section 9. And so why is that relevant? Well, then you get into, under Section 9, the test that one has to apply as to whether you get a mandatory stay of court proceedings or legal proceedings in favour of arbitration proceedings. And then there are two sort of broad issues which come out of that, which I think are particularly relevant in the insolvency context. The one is how the court approaches whether it identifies a matter which is capable of being stayed. And then if you're engaged with Section 9, the court will order a mandatory stay unless it determines that the arbitration agreement is not effective. In this case, the relevant test would be inoperable. And that would be on the basis that the court is being asked to deal with matters which aren't arbitrable. So even if Section 9 is engaged, you can't refer it to arbitration because the arbitration agreement is ineffective. That's the one caveat to the mandatory stay, as it were. So just picking up on those two issues, which I think are pretty interesting. Many of you might know that there was a sister case issued by the Supreme Court here at the same time as the Family Mart decision, and that's the case of Mozambique. Mozambique really hasn't anything to do with insolvency proceedings. It was an insolvency case, but both of those cases set out the approach that the court will take to identifying whether the legal proceedings before them raise a matter which ought to be stayed. So it's probably just worth looking at, going very briefly through what that test was. So particularly because it's very new and it's from the highest courts here. So that's a two-stage process. First, the court will determine whether the matters the parties have raised or foreseeably will raise in the court proceedings. So they get, and then the second stage, once you get past that of looking at what's been raised in the court proceedings, is in relation to each of these matters, whether it falls within the scope of the arbitration agreement. So for present purposes, probably what's more interesting is the initial stage of the test. So in that case, what is a matter which the parties have raised or foreseeably raised? In ascertaining that, the court looks at the substance of the dispute. the matter doesn't need to encompass the whole of the dispute, and but the matter does have to be a substantial issue that is legally relevant to the claim or the defence or a foreseeable defence in the legal proceedings, and is susceptible to being determined by an arbitrator as a discrete dispute. So it's something more than a mere issue or question. That also involves a judicial evaluation, and also the court, when looking at this question, can have a regard to the context in which the issue is raised. So when we take back and we look at the question of insolvency, the winding up petition, which was presented in the Family Mart case, overlaying with that test of whether you're looking at the matter is this question of whether or not the arbitration agreement is not operative. In the insolvency case, obviously that raises some quite interesting issues. There are two types of arbitrability which the Privy Council goes through in Family Mart. The first is subject matter arbitrability, and that's where a dispute is excluded by the subject matter or public policy. Either that's done by way of legislation, so you can think of employment disputes, or it could be something which is in the public interest, which should be reserved to the court determines should be reserved to public courts or tribunals, i.e. not confidential. And that's potentially relevant in the liquidation context. And the Family Mart decision gives the example of the Singapore case of Larson, where claims by liquidator of an insolvent company for avoidance of unfair preferences and payments with intention to defraud was something which the Singapore court refused to decided was not arbitrable on the basis that it was pursued by the liquidator for the benefit of the company's creditors generally. Then also relevant is the second type of non-arbitrability, which is remedial non-arbitrability. And here, particularly reference is made to the fact that tribunals cannot make a winding order for a company, because obviously tribunals can only make intra-parties orders, and a winding up order for a company is an in rem order which affects third parties. So if we go back to the Family Mart case and look at what happened here, there are a number of issues which were raised in the Family Mart case in the winding up petition, but two of those were ones which the court found were only capable of being resolved by arbitration under the shareholders agreement, and those were issues which went to essentially whether or not there had been a breakdown in trust and confidence of the majority shareholders. And in order to answer that question, you had to look at the obligations under the shareholders agreement. And those were said to be substantive and highly relevant for the basis of winding up. So the court did order a Section 9 equivalent stay in relation to that. Then the court had to go on and say, well, okay, so what do we do in relation to the rest of the winding up proceedings? And there, what the court ordered was a case management stay, and it said it recognised that winding up proceedings were of a special category and would normally be decided quickly, but they said consistent with the overall scheme for arbitration and being supportive of arbitration, they thought that the right thing to do was to grant the stay so that the two issues which were arbitrable and satisfied the test in Family Mart and Mozambique could be resolved first before you came back to deal with the remainder of the winding up petition, given that they were essentially precursors issues to the rest of the winding up. So I think that covers it, Patrick, or at least what I was going to say initially, unless you have any questions.
No, that's great. Thank you, Angeline. So obviously been a lot of, I think there's been an increase in the volume of cases that we're seeing on these issues, which also reflects the fact that arbitration and insolvency are coming into conflict more and more, or coming into contact more and more. And obviously this is not just happening in England, because these issues often involve cross-border insolvencies. So are there any major differences of approach between the current approach in England and other major arbitration centres such as Singapore and Hong Kong? And I wonder, Emily, whether you might explore that a little for us.
Yes, so the decision in Cyan and Halameda means that we are now on a different course from the approach that's being taken in the common law jurisdictions, so Singapore, Hong Kong, Malaysia. And interestingly, there have been three important decisions in this area in Hong Kong in the last 18 months. So it's like London buses, you don't get anything for a while and then you get 3 very important ones coming along all at once. And 2 of them came out on the same day in April this year, which was after the hearing in Alameda, but before the judgment had come out. So 2 are confirming a different approach from what eventually happened in Alameda. And spoiler alert, the approach in Hong Kong and Singapore is generally that a winding up petition is likely to be stayed or dismissed if the debt under which that petition has been raised arises further to a contract that contains an arbitration clause. Now, there is a safety valve in that the courts retain a discretion where there are countervailing factors, such as a risk of damage to other creditors, or if the dispute borders on being frivolous, but query what the difference between that is and whether it's a substantial dispute. So there is a difference of approach now because of the decision in Sian and Alameda. And I'm going to just run through those 3 Hong Kong cases very briefly, because they suggest that a decision to proceed with insolvency, so once a petition has been presented, the decision as to whether or not you proceed is something akin to summary judgment. So although on the surface, the practical outcome of the approach might look similar, the underlying rationale for these decisions is, in my view, quite different. So the first case is the most authoritative, and it was from the highest court in Hong Kong, the Hong Kong Final Court of Appeal, and it's called Re Gai Kwok Hung Lam. It's known in the other authorities as Gai Lam. And actually, it's not a case about an arbitration clause, it's about an exclusive jurisdiction clause. And just to give you the facts very briefly, Mr. Lam, who was the debtor, is a Hong Kong resident who had founded various companies that provided care for the elderly in China and in the United States. And a creditor had extended a loan facility to one of these companies. The loan facility contained this exclusive jurisdiction clause in favour of the courts in New York. Mr. Lam had given a personal guarantee in respect of that liability. That guarantee also contained an exclusive jurisdiction clause in favour of the New York courts. The lender said the company was in default, and it called in the debt and made a claim under the guarantee. And it presented a petition against Mr. Lam in Hong Kong for a bankruptcy order against him. Now, while that petition was on foot, Mr. Lam started an action in New York in reliance on this exclusive jurisdiction clause, and he sought various declarations. He said the lender hadn't given him notice, there was an estoppel argument he was running about the lender not being able to rely on an event of default, and he said that the enforcement action was being taken in bad faith. So he wasn't really attacking the debt, it was a sort of kitchen sink approach as just trying to slow things down and postpone the evil day. So on the Hong Kong petition, at first instance, the judge made a bankruptcy order against Mr. Lam. But on appeal, the Hong Kong Court of Appeal allowed the appeal and dismissed the petition on the basis that primacy should be given to the exclusive jurisdiction clause, the party agreement as to how disputes should be managed. This is in line with the Salford Estate line of cases, so that they're following that sort of line of cases. Now, the lender appealed to the final Court of Appeal in Hong Kong, and they agreed with the Court of Appeal, i.e. that the petition should be dismissed. And what they did was they focused on the discretionary factors in respect of allowing the petition to continue or not. And they said they were exercising their discretion when they looked at a petition as to whether they were satisfied with the proof of the petitioning creditor's debt, whether they were satisfied there was a bona fide dispute on substantial grounds, and they retained a discretion in any event. So they're focusing very much on the discretion, which means that they can bring into play balancing policy considerations between insolvency policy, i.e. making sure that creditors are paid, and the policy of giving effect to the parties' agreements. Interestingly, in the Gai Lam case, they said that the court, in allowing the petition and making the bankruptcy order, had undertaken a summary judgment type determination. And so it assumed that jurisdiction that the parties had agreed should be the exclusive preserve of the New York courts. Also relevant in this case was that there were no secondary creditors. So there was nobody going to stand up if this creditor was paid. There was nobody waiting in the wings. And the court said, well, it would have been very easy for this creditor to go to New York and get summary judgment. And so the approach was very much the Salford Estates type approach, but as applied to an exclusive jurisdiction clause. Now, the next two cases came out on the same day. It was Re Simplicity and Vogue Retailing and Re Shandong Chenming Paper Holdings. And both of them were bang on point, arbitration clause in the agreement that gave rise to the debt on which the petition was based. Neither case was particularly meritorious in favour of the debtor, so it's very easy for the court, it would have been very easy for the court to allow the petition to proceed. So these are very clear indications. They didn't allow the petitions to proceed. They said that they should be stayed or dismissed because of the arbitration clause. In the Re Simplicity case, it was a debt claim under a guarantee again in relation to bonds, where the bonds had been issued and repayment of the bonds was guaranteed. The guarantee and the bond contract contained an arbitration clause. The creditor had issued a statutory demand, which had been part paid. So the debt essentially was admitted, part payment of the debt had been made. And a statutory, because the remainder of the debt was unpaid, they presented a winding up petition against the company. Now, in terms of the procedure in Hong Kong, the debtor didn't appear at the first hearing, which meant that the debtor either had to pay the money into court or pay a substantial amount of the money into court if it wanted to contest the debt in any way. It wasn't able to do that, but it put in evidence saying that it was going to rely on the arbitration clause. And at the hearing, the court found there was no credible evidence that it would be able to, even if more time was allowed, it wouldn't be able to come up with the money. But in terms of the arbitration clause, the court found that Guy Lam applied equally to arbitration. So where there was an arbitration clause, so the arbitration clause should be given primacy. And in the Simplicity case, it had endorsed a gloss on the Salford Estates test, whereby if the debtor is going to be relying on an arbitration clause, it has to be seen to be taking steps to get the arbitration off the ground. So the situation at the moment in Hong Kong and other common law jurisdictions is that primacy is given to the parties' agreement in the arbitration. Although, as I said, there's a safety valve, they do rely on discretion. So given the decision in Alameda, it will be relatively easy for the courts in other jurisdictions to pivot and say, well, actually, let's now focus on the insolvency public policy considerations. Although, as I said, the approach that they've taken is that when the insolvency court takes jurisdiction, they are actually interfering with the arbitration agreement. They're making a decision about the debt. So they are going to have to find a way to get around that fundamental difference between their approach and Alameda. So yeah, the answer to your question, Patrick, is yes, there are differences now. We're on a different path.
Thank you, Emily. So one of the attendees today, James Wagner, has raised an interesting observation. He says, fascinating observations on Sian and Salford. Isn't the common sense practical effect of Sian that a claimant needs to flush out, or the creditor, sorry, needs to flush out whether there is a genuine dispute as to the debt in pre-action or arbitration, pre-arbitration correspondence? If yes, then you go to arbitration. If no, or if the debtor goes quiet, you quickly and cheaply proceed with a statutory demand. Anyone like to comment on that observation?
I'm happy to comment. Sorry, James, you gone.
No. I'm happy for you to go ahead, Emily. Go ahead. I can always add something at the end.
I was going to say that makes perfect sense. I think from my perspective, the Sian decision is a fantastic boon to arbitration, because it stops, as I said earlier, any faffing about when there is absolutely no genuine dispute. And it's actually, if there is a genuine dispute, it's not that difficult to show that to an insolvency and companies court judge. James.
Yes, no, I mean, look, I do agree with that, but I think the only caveat I would add is just it's not beyond the wit to imagine that an unscrupulous party would simply go ahead and either go, service that demand, and then we're sort of, or in terms of a company, issue a winding up petition. And yes, there may be cost consequences of doing that, as the courts have determined, but you could then be forced dealing with, I guess, from an arbitration perspective, these sort of disputes in different fora, having to resolve things. And I think that's just the concern from my perspective. But look, the reality is the ICC judges are, incredibly smart and sensible, and I doubt they would want to go down that line in terms of how this case law develops. But look, I do think there is a concern that parties may be dragged into matters before the English courts.
So we wanted to explore, I think, the last topic we wanted to do before we turn to more questions, a sort of an example of what would happen effectively if you have insolvency proceedings overseas and arbitration in London, and the kinds of considerations that you need to, practical considerations you need to take into account if you're working in a matter where that's the case. And so, Emily, maybe you could sort of lay out some of the considerations for us.
So we've got let's assume we've got an arbitration going on in London and an insolvency in a different jurisdiction, insolvency abroad. So it raises all sorts of, insolvency in a different country raises all sorts of issues. I'm just going to outline 5 very quickly that I've come across and my colleagues have come across. So the first and most important question is probably, is there an automatic stay of the arbitration as a result of the foreign insolvency? And that's probably going to depend on whether the foreign insolvency has been recognised in this country. If it has, there probably is an automatic stay. Secondly, as a matter of practicality, there probably needs to be at least a short case management stay in the arbitration. Let's assume the arbitration is ongoing, has been on foot, and the insolvency has happened after the arbitration has been on foot. There's probably going to need to be a short case management stay to allow the parties to take stock, and most importantly, if an insolvency practitioner has been appointed in the foreign jurisdiction, if it's that sort of insolvency, to allow him or her to get up to speed with what's happening in the arbitration and decide whether they want to support it or not, or continue with it. Thirdly, even if the insolvency practitioner doesn't want to participate, they have to be kept informed. They should be kept informed of what's going on in the arbitration. If the other party pursues the arbitration and wants an award, you've got to have an eye on the New York Convention. You don't want the debtor to be able to say, well, we weren't able to take part or put our case forward. So keep them informed. Fourthly, and I know other people have got different views on this, but you might want to be careful about who you continue to communicate with in the context of the arbitration. So if you've been dealing with the directors of the company, the insolvent company, and their lawyers, and the insolvency practitioner has taken over and those directors no longer have any standing in the company, it raises questions of confidentiality, keeping the confidentiality of the insolvency. And finally, it's important to understand how the assets might be arranged in the insolvency, whether certain assets are directed towards certain liabilities, so that if necessary, the award that you're seeking is pointed at the right asset. So, for example, if the insolvent party is a company that runs a number of funds and you've got a claim in respect to one of those funds, do you need to make sure that the award is pointed in the direction of that particular fund rather than generally the assets of the company? So those are the thoughts I had on that, Patrick.
Thanks, Emily. And Angeline, any other issues relating to confidentiality or anything similar to that?
No, I mean, I think confidentiality is quite an interesting point. It may well be that the arbitration remains confidential for its duration so long as it continues, but any outcome of that arbitration may not remain confidential if it's brought into the insolvency proceedings, because then you engage a much broader interest. And I think sometimes the mistake is made that confidentiality obligations are bulletproof, but at the same time, there are some important general public interest caveats to that, at least as a matter of English law. And so I don't know. I think it would raise really interesting questions as to whether or not actually it would remain confidential, at least as soon as you get the award. and what you do with that award in the insolvency proceedings.
And Kushal, where you've got these cross-border situations, are there any ways of restraining, or would it be to anyone's advantage to seek to restrain the proceedings that are going on overseas in favour of the ones going on in England?
Yeah, so I guess, you know, there's in my mind, there's two broad sets of scenarios, right? Where one is where you've got an English law agreement with an English seated arbitration, and there are foreign insolvency proceedings that are ongoing. And what you're trying to do is you're trying to avoid somehow being caught up in those foreign insolvency proceedings by the office holder in those proceedings, either disclaiming the contract or somehow reaching some kind of adjudication in relation to your agreement, which is arbitration. Now, I can sort of see that in that scenario, there might be some first mover advantage in if you've got an arbitration agreement to quickly commence arbitration, in England, if, for example, the insolvency has not yet been recognized in England, or no application has been made to recognize it in England. And then if you particularly got a scenario where assets belonging to the counterparty are in multiple jurisdictions, you might sort of try and, you know, get an arbitral award relatively quickly that you then try and enforce in another jurisdiction in which the insolvency has also not yet been recognized, almost trying to get ahead of some of the other sort of creditors in the insolvency. So I think that's sort of one thing that is still at play, I think. And in that context, there's also the assistance you may get from the English court, where if in the foreign insolvency proceedings, a liquidator is trying to disclaim the contract, which is subject to arbitration, or reach certain findings, you know, there might still be scope to sort of go to the English court and say, hang on, this is an English law agreement, English seated arbitration. I'd quite like an anti-suit injunction, please, preventing the liquidator sort of, you know, making any decisions without coming to arbitration. It's a sort of river rock type scenario that we're looking at. I think the other way around, where you've got an English insolvency, but you've got a foreign seated arbitration, and if you are the liquidator in that situation, one of the things you could try and, or will want to do, is try and seek recognition of the liquidation proceedings relatively swiftly, particularly in the jurisdictions in which the arbitration is meant to be seated or is seated, so that you can then try and benefit from whatever the equivalent regime is of, you know, getting recognition for the moratorium, or seeking the assistance of the local courts in preventing the arbitrators reaching conflicting decisions in relation to the debt or whatever it may be. So I think those are probably tactical things that parties will still have to consider, I think, notwithstanding the whole sort of you know, can you even bring the winding up petition? This is more about, well, what happens if something is already on foot? And I think the cross-border aspects are quite interesting. You know, I think from an insolvency perspective, there's this whole idea around universalism, and sort of that it should all prevail. But I still think there might be arbitrage opportunities for parties if they've got arbitration agreements in particular in their contracts. You're on mute, Patrick.
Thank you. So we've got 5 minutes left, and a couple of questions have come in. So the first question is from Chris Southworth. He says, do you see any impact from the change of UK government or increasing political pressure globally to deal with disputes in a particular way, i.e. governments influencing the appointment of judges and influencing courts? Does anyone want to have a go at that?
I'm happy to pick it up, but I won't address it. I think what we get from the case law that we've just discussed is not so much. I mean, if you're thinking about the English courts, and I don't think any of those things are particular issues. But what I do think is quite interesting from the decisions that we've seen in Sion and Family Mart and Mozambique, but in a different context, is what the English court is now grappling with, I think, is trying to work out what is the boundaries of circumstances in which court proceedings should be allowed to proceed or not proceed in the face of an arbitration agreement. And ultimately what you have is a sort of, via different routes, a balancing exercise to see whether the issues which are really being raised in the English court proceedings are substantial issues which ought to be referred to arbitration, and if they're not particularly substantive or they're de minimis, then the court will proceed. So I think in a sense what you see there is a bit of a recalibration as to how, or balancing as to how far the court goes in terms of supporting arbitration. I mean, I think it's clear that it is very supportive, but there's also a kind of practical reality of here is to, we're not going to stay anything if actually the matter which is in dispute before the English court, which would go to arbitration, is not determinative or is not substantial. And actually, when Kushal was speaking about anti-suit injunctions, I was thinking that I'm not quite sure that that would be baked into case law and anti-suit injunctions in quite the same way. That tends to be a bit more binary, are you within the agreement or not? But that I think is what we take from the recent English case law, and I think it will percolate out, as Emily says, into other jurisdictions as they sort of grapple with that balancing act, potentially a bit more in future.
Thanks, Angeline. So I think we've got time for one more question. We have a question here. How does the UK Privy Council stance in Sian and Alameda affect the interplay between the principle of party autonomy in arbitration agreements and the pari passu principle in insolvency, particularly when a creditor uses insolvency proceedings as leverage to resolve a disputed claim outside of arbitration? James, do you want to have a go at that?
Yes. Well, I think the way Sian deals with it and how they deal with it is essentially to say, well, if there's a genuine and substantial dispute, and that's obviously something which needs to be sent to arbitration, I'm not sure that directly impacts the pari passu principle. I mean, if the question is directed more at, let's say, a party threatens a winding up petition now based on Sian, and then a deal is done, let us say in relation to an unsecured creditor. So a deal is done, and if nothing ever goes into insolvency, then that's absolutely fine, and that will endure. But I think the concern may be, but this is the case generally, there could be a situation where if the company ultimately goes into insolvency and a liquidator is appointed, a liquidator may then investigate whether that may be a transaction at an undervalue, or there may be arguments in terms of preferences. So all of those sorts of usual remedies, which of course are available to a liquidator, would still apply. But I don't think, from my view, I don't think Sian and Alameda really impacts that. I think those things are there regardless. So even if a party threatened arbitration and then a deal was done, the company ultimately went into liquidation, a liquidator will still have those powers. So I don't think there's a direct relationship between the two.
If I may just
add
something on that, just on the party autonomy point as well, because it's the one thing I have been reflecting on following Sian is, and I think Emily made this point, which is, if there is a genuine dispute about a debt, then the threshold doesn't tend to be very high to demonstrate that in the court to set aside the winding up petition. But I do wonder whether practically, where you do have an arbitration agreement in place, whether that threshold might inevitably be marginally lower in our courts in England, because when parties are providing evidence around the dispute of the debt and sort of getting drawn into the arguments around it, I do wonder whether some of the ICC judges might be more willing to slightly lower the threshold where there's an arbitration agreement as a matter of practice, to recognize the party autonomy and the fact that there is an arbitration agreement that sits under it.
Thanks, Kushal. We'll have to leave that question hanging because we're out of time, but thank you very much to all of our panelists for the very engaging discussion. Really appreciate it.
Thank you, Patrick. And yeah, thank you ever so much. That was fascinating. And just to point out, these sessions, the ideas and of the topics come from our members. And Patrick, this came from your firm. So we do encourage our members to get in touch and let us know what they would like to talk about. We're going to be doing the next call for papers for the 2025 events probably shortly. So do put your thinking caps on, but all of these sort of discussions, they don't come necessarily from us at the ICC, they come from you, our members. So we're really, really keen to hear from you onto what else you would like to talk about in perhaps next year's events. So just conscious of time, because we're back to back today. Our next session starts at 1:30. It's our final webinar of the day on expedited procedures, which I have on good authority, and also by being on the speaker calls, it is going to be interesting and quite controversial. So I do encourage you to join that webinar if you can. If you can't, like all of the others, we will be making them available on our YouTube channel after the event. And for those that are joining us tomorrow, do make sure you're there in person from 9 AM for registrations. It's going to be a busy day with over 170 people now registered. So looking forward to seeing those that can make it in person tomorrow. Thanks again, everyone. Thanks for all our speakers for today. And thank you very much, Patrick, for moderating this session for us. Take care.
Thank you.